Well, good morning, everyone, and thank you for having us. It's a pleasure being with you to just talk about some, well, on my part, talk about some of the most recent updates to the FMCSA safety regulations. Just a little bit of background on us and our firm. As Brett said, my name is Brandon Wiseman. I'm one of approximately 85 attorneys or so that work at our firm, the Scopelitis law firm. Kelly and I are both based out of Indianapolis. We have offices all across the country now. Our headquarters is really Indianapolis, though. Our firm is unique in the sense that we are one of the only, if not the only, firm in the country that whose entire practice is really devoted to the transportation industry. And what I mean by that is all of our attorneys spend the vast majority of their time representing motor carriers and shippers and brokers and all kinds of entities in that industry on various topics, ranging from mergers and acquisitions to regulatory compliance, independent contractor issues, safety, and everything in between. So my focus, or my practice, focuses primarily on the DOT safety side of things, which means that I help clients with making sure that their safety programs are in order, that their operations are in compliance with the multitude of safety regulations that govern their businesses. I help them through DOT safety audits if you get the unfortunate knock at the door from the DOT, and then I also help them with appealing any kind of fines that they may get and that type of thing. So, with that in mind, and given that line of work, I'm watching the FMCSA safety regulations pretty closely, and so that's what we're going to talk about today. There's been quite a few updates recently to the FMCSA safety regulations, so we're going to hit some of the big ones. This is not all of them. The agency's been pretty busy over the last year or so in terms of its regulatory agenda. So they've come out with quite a few new regulations, and we're not going to have time to talk about them all, but we'll talk about the big ones. Here is a list of probably the most significant rulemaking that's happened over the past year, and the top three are, in my mind, probably the most substantial rulemakings. So we're going to focus on those. Before we do, let's talk a little bit about the bottom three here. The first is the driver coercion rule. It's a final rule, so the rule's in place now. It's a rule that came out last year. And this is one that prohibits not only motor carriers, but also shippers and brokers, third-party intermediaries, from coercing a commercial motor vehicle driver to violate a number of the safety regulations, probably most notably the hours of service regulations. And so this rule is significant for several reasons, but probably the most significant reason is that it's the first time the agency has ever exercised its jurisdiction over brokers and shippers. Traditionally, the Federal Motor Carrier Safety Administration, you can tell by its name, it's usually been focused on motor carriers, but with this rule, they are extending their reach to shippers and brokers and saying, hey, third-party intermediary, you cannot coerce a driver to violate the hours of service regulations, for instance. It starts to get tricky when we get into what does it mean to coerce a driver to violate a safety regulation, and we probably don't have time to get into that, but essentially it's the thing to keep in mind with this regulation is that it requires a specific driver complaint. So it stems from the driver thinking that he's been coerced, filing a complaint with the agency, and then he has to have documentation, he or she has to have documentation that, yeah, he was coerced into violating a safety regulation. And then if he can prove that case, then the carrier or the broker or the shipper is potentially liable for some pretty hefty fines, up to $16,000 per violation. The next rulemaking it deals with sleep apnea. And so sleep apnea is a topic that has It's certainly been an issue in the industry for several years now. It's one that it isn't currently regulated by the FMCSA. The FMCSA currently has no regulations that would say a driver is disqualified just because he has sleep apnea. Right now, it's kind of just handled by the medical examiners. So if a medical examiner who is certifying a driver to drive a commercial motor vehicle thinks that this driver has sleep apnea and that would inhibit his ability to safely operate a commercial motor vehicle, then the medical examiner can put any kind of restrictions on the medical card that he wants. But that's all there is currently. And so over the past several years, the agency has been thinking about what it needs to do, if anything, about regulating that. And so recently, the agency, along with the Federal Railroad Administration, has come out with an advanced notice of proposed rulemaking. And this is essentially just telling the industry, hey, we're thinking about coming out with a new rule that would do something about sleep apnea. We want to hear from you guys about how that condition impacts you and your operations. So over the course of the last few months, they've been holding some listening sessions across the country where they're just trying to gather some information on the condition and figure out what they need to do. So they haven't issued any kind of proposed rule yet. It's possible that they will in the near future. Drug and Alcohol Clearinghouse. So this was a proposed rule that came out, it's probably been a couple of years now ago. And it's one that establishes essentially a central repository for drug and alcohol testing information, results from commercial drivers getting tested for drugs and alcohol. And all of those test results are to be funneled into this central repository, which then makes it easy. The idea is that it makes it easier for carriers that are bringing on new drivers to have access to, hey, has this potential driver ever tested positive for drugs or alcohol in the past? So this was a proposed rule that, like I mentioned, that came out a couple of years ago. We would have expected a final rule to come out, frankly, last year. We haven't seen one come out yet, and so that central repository is not yet set up, but we expect that it will be set up in the near future. When it is set up, then that's when all of the drug and alcohol testing results from commercial drivers will be funneled into that. So getting into then what I think to be the most significant rulemaking in terms of safety regulations, we'll start with the entry-level driver training rule. This was a proposed rule that came out late last year. The comment period is now closed. It was closed in April. And so we're just kind of waiting to figure out what the agency is going to do with it. Are they going to move forward with the final rule? Are they going to make any changes to it? That's kind of the stage we're at. So what does the rule do? Well, before we talk about what the rule does, it's important that we start with what the rules currently require in terms of entry-level driver training. That way we can get a better sense for what the new rule is changing. So in terms of the current requirements, and I find that a lot of my clients aren't even aware of this rule. It's kind of tucked in some odd places in the safety regulations, but essentially any driver that you're bringing on board, and I'm talking about CDL drivers, if that driver has less than 1 year commercial driving experience, you as a motor carrier have an obligation currently to provide him or her entry-level driver training on 4 specific areas. Those areas are driver qualification, hours of service, driver wellness, and whistleblower protections. You're supposed to be providing that training and then documenting that he or she completed that training in the driver's qualification file. That's the current regulation. The proposed regulation, which again is not final yet, is going to completely overhaul how that works. Currently the onus is on the carrier to make sure that that entry-level driver training gets done and documented. But under the new rule, it's going to shift that burden off of the carrier and onto the commercial drivers. And so essentially what the rule is doing is it's establishing new requirements for any driver who is going in to get his CDL for the first time, those reapplying for a CDL following disqualification, and those seeking to upgrade their CDL from Class B to Class A, for example, or those seeking to add an endorsement to their CDL. That's who the new rule will apply to. There's some exceptions which, they're for military and farmers and firefighters. The rule can be broken down into two parts. There's the first part that applies to the drivers that I just mentioned, and then there's the second part that applies to those entities that are going to be providing the training, and we'll talk about those in a minute. In terms of the requirements that apply to the drivers, the rule is setting up essentially a two-part training program. There's a core, it's called the core curriculum. There's a theory component, which is essentially a classroom component, and then there's a behind-the-wheel training where they have to get out on the road and do training either on a closed circuit track or actually out on public roadways. And so the idea is, or the proposed rule is that drivers who are seeking to get a Class A CDL would have to have a minimum of 30 hours behind-the-wheel training before they would be eligible to take the skills test to then get their CDL, in addition to the classroom component. Those that are seeking a Class B CDL, which is for the smaller vehicles that are still over 26,000 pounds, but straight trucks, non-articulated trucks, they would have to have a minimum of 15 hours behind the wheel training. And like I said, the idea being they have to complete this training before they would be eligible to take the skills test in whatever state they reside to get their CDL. In terms of the rules that apply to the training providers, so the rule establishes this new system where there's going to be these third-party training programs that are going to be providing this training to the drivers and then certifying that the drivers completed that training and are eligible to take the skills test to get their CDL. The rules that they have for the training providers are pretty specific in terms of what the curriculum has to include, how the program has to be administered, the qualifications for the trainers that they employ, the tests that they give, and then they have to be able to, like I said, certify once the driver has successfully passed the training, and then upload that certificate to some kind of database that's going to be set up, which the states would have access to see, yeah, this driver has passed the training, he or she is eligible to take the skills test. The training providers will have to be listed on the FMCSA's list of certified training providers. So that's the training rule. I just wanted to point out that this has a pretty long implementation date. So the way the rule's set up, like I said, it's not even final yet, but the way it's set up is that when it becomes final, it's not even going to take effect until 3 years after that date. So this is a long way down the line, really. And the reason it's pushed so far out is because they need to give the individual states time to amend their laws and regulations to essentially incorporate these new procedures into their state laws and their state CDL protocol. So we've got quite a while before that comes down the pike. The next big rule that we saw come out in the last year or so is the electronic logging devices rule. I'm sure you all are at least somewhat familiar with this rule, and I think Doug Pope is going to speak about this more in depth later today, so I don't want to step on his toes any. So I'm just going to kind of go briefly over what the rule requires and let him get more in depth about it. But essentially the rule, if it sounds like deja vu to you, it's because the agency had already implemented a final rule that would have required electronic logging devices in the trucks back in 2010. You probably remember that. And we were in the same position back then that we are now, where, hey, what's this mean for carriers' operations? Are they going to have to invest in all of this equipment, et cetera? Back in 2010, you might recall that final rule got challenged by the Owner-Operator Independent Driver Association in federal court and was overturned by the Seventh Circuit Court of Appeals. So that final rule that happened back then was kind of pushed off to the side. The agency went back to the drawing board, came up with a new rule that they think addresses the court's concerns with the original rule. And so they published this final rule last year. Last year. And now we're in a period where we're between the final rule and the effective date. The effective date is December 18th, 2017. That's when every carrier, with some few exceptions, which we'll get to here in a second, will have to have electronic logging devices installed in their commercial motor vehicles to track their drivers' hours of service. Again, I'm going to try not to step on Mr. Pope's toes here. So just real quick, the exemptions. Probably the most significant exemption that's going to be applicable to some carriers is essentially the short haul exemption. The electronic logging devices rule will not apply to drivers who complete records of duty status, driver logs, fewer than 8 days in any rolling 30-day period. Essentially what this is getting at are those drivers that are currently on time cards because they fall under the FMCSA short haul exemption. So those drivers that are operating within 100 or 150 air mile radius of their normal work reporting location and then are returning within 12 hours, in other words, they're not working more than 12 hours in a given day. Those drivers are currently exempt from the driver log requirements. They just have to keep a time card that says what time they start each day and what time they end each day. This new electronic logging devices rule carves those drivers out and says those drivers do not have to have an electronic logging device installed in their vehicles. It starts to get a little confusing when you look at this idea that when it talks about drivers who complete driver logs fewer than 8 days in any 30-day period. Essentially what that means is, so even under the current short haul exemption, if you have a driver who typically falls under that exemption and then for whatever reason one day he needs to go beyond the air mile radius or he needs to work more than 12 hours in that day, you know, that's fine. He just has to fill out a driver log for that particular day. And so what the electronic logging device exemption is saying is that, okay, as long as you have drivers who fall under that short haul exemption, and he's not exceeding the scope of that exemption 8 days or more in a given month, then okay, he doesn't have to have an electronic logging device. But if in that month period he's exceeding the scope of that exemption and having to fill out a driver log 8 times or more in a month, then he will have to have an electronic logging device in his truck. So I know that gets a little confusing. It's worded pretty confusingly in the rule, so we can talk about that if you have questions here at the end. But that's the biggest exemption. There's some others. The rule also talks a lot about, you know, if you were to print out this final rule, it would be, no lie, probably a couple reams of paper. The bulk of the regulations are the minimum capabilities of the electronic logging devices themselves. And so those rules are really aimed at the companies that are going to be manufacturing the devices. You know, I've kind of got a list here of some of the big items that they have to be capable of doing. Essentially, the biggest item is that these devices have to be synchronized with the vehicle's engines so that they can automatically start recording when a driver begins to operate the vehicle. It'll kick them into drive time. And then, you know, it still requires some manual entries from the driver when they're switching, you know, for instance, from sleeper berth to on duty, not driving, et cetera. It still requires some manual entry, but that's the big component, is that it's automatically recording when they're driving, and the idea being that this is going to hopefully reduce log falsification. It's going to reduce the ability of the drivers to manipulate their logs to violate the hours of service rules. That's the hope. You'll probably hear later today about the supporting documents requirement. You know, currently under the current rules, even with paper logs, you as a carrier are supposed to be keeping supporting documents that you can use to verify the accuracy of your driver's logs. So if your driver goes out on a trip and he stops to get fuel, you're supposed to be keeping his fuel receipt so that when he brings his logs back to you and he marks on his log that, yeah, I was at this location at this time getting fuel, then you can look at his fuel receipt and match it up with the log to make sure that he's not falsifying his log. The same is going to be true under the electronic logging device rule when it comes into effect. You're still going to have to maintain supporting documents, and they have a whole list of documents that could be considered supporting. Your obligation as a carrier will be to retain up to 8 supporting documents for every 24-hour period. Now, that doesn't mean you have to keep 8. That just means that if in the normal course of your business you generate more than 8 types of supporting documents, you don't have to keep more than that amount. It's kind of a ceiling. In other words, you don't have to keep anything more if you were to generate more than that. So, but if in the normal course of your business you only generate 2 or 3 types of documents that could be considered supporting, where you can verify the accuracy of the driver's logs, then that's all you have to keep. I want to talk about this last part because I think it's important. It's the privacy and driver harassment issue. Now, I mentioned earlier that the reason, well, I didn't mention the reason, but the earlier 2010 final rule was thrown out by the Seventh Circuit Court of Appeals, and the reason it was thrown out was because the court said, FMCSA, you didn't do anything like Congress directed you to do to address the concern about using these devices to harass drivers or to invade their privacy. In other words, there was some concern primarily by OOIDA that, hey, these devices are going to be used to, these drivers are sleeping in their sleeper berth, you're going to be using them to wake them up and make them drive when they're out of hours, et cetera. So the court said, yeah, we don't think you agency have done anything to address that. So they threw the rule out. FMCSA went back to the drawing board, and they have addressed it in the final rule, the new final rule. And here are some of the components that get to that topic. So under the new rule, the ELD device must have a mute function so that when the driver's in the sleeper berth, it can be muted and they're not bombarded with alerts from the device. The GPS location radius that's captured has to be different, has to be bigger when the driver is using his vehicle while off duty. So if he's using his commercial motor vehicle for personal conveyance, the GPS location that's tracking him has to be expanded to a 10-mile radius. So when he's on duty and driving, it's a 1-mile radius. The device has to be able to track him within an accuracy of 1 mile of where the vehicle actually is. When he's using his vehicle while off duty, it has to be expanded to 10 miles. That's another component that's ostensibly addressing driver harassment and privacy. There's a couple others that are not as significant. The last thing I want to talk about, hit on with respect to electronic logging devices is that OOIDA has filed another lawsuit challenging the new rule. So the rule came out late last year, and I think the day after the rule came out, OOIDA filed a lawsuit in 7th Circuit again, challenging the rule on several grounds, probably the most significant of which is that the agency didn't do enough to address driver privacy and harassment. So this case is fully briefed now. It's ready to be decided by the court. We don't know when that will happen. If the last case is any indication, we're probably not going to see a decision on this until late this year, but probably next year would be my guess, early next year. And I have the opportunity to give these presentations quite a bit, and I always get asked the question of, well, what's the court going to do? Are they going to throw out the rule, or are we going to have these devices implemented by next December? And, I always say, well, I wish I had a crystal ball. I unfortunately don't, and so it's hard telling what the court's going to do. But if I had to guess, having read all of the briefs and having been involved and read the previous case, my inclination is that the court is not going to throw this rule out. I think the agency did enough to satisfy the court that it has addressed the driver privacy and harassment concerns in the new rule. That was the court's big concern in the last case. I think they've done enough to satisfy the court. I would guess that the rule is going to stand and that you're going to have to plan on implementing these devices come December, next December, not this December. The last big rulemaking proceeding that I wanted to talk about, and this is probably the most significant in my mind, although electronic logging devices is certainly significant, is the proposed change to the safety fitness determinations. These are your safety ratings. The agency has had their current safety rating process or safety rating system in place for several years now. You probably become used to it, you understand it. They came out with a new rule late last year that's going to completely overhaul how carriers get assigned a safety rating. And it gets pretty complex pretty fast. So I just want to spend some time kind of unpacking it and going through with you what I think that's going to mean for your businesses. Before we do that, let's talk about how the current system works, again, so that we can see and appreciate what the changes are. So the current safety rating process, as you probably know, is a 3-tier rating system. Carriers have they have one of 3 ratings, or they have no rating at all. So the 3 ratings that exist currently are satisfactory, conditional, and unsatisfactory. A satisfactory rating means everything's good. You can continue to operate, no restrictions or anything like that. An unsatisfactory rating, as you can imagine, means everything is not good. In fact, you are out of business. You are out of service. You cannot operate. Something the agency has discovered is so serious that they are prohibiting you from operating. A conditional rating is somewhere in between, where the agency has found problems with your operations, but you can continue to operate with a conditional rating. Now, that may affect your business relationships with shippers and brokers, because a lot of those entities don't want to do business with a carrier that has been flagged by the FMCSA with some safety problems and therefore has a conditional rating. So, those are the 3 safety ratings. As I mentioned, you may also not have a safety rating at all. In fact, the vast majority of the regulated carriers in the country don't have a safety rating. And the reason is pretty simple. In order to currently get a safety rating, the agency has to come in and do a full-blown compliance review of your operations, where they're looking at your records in various areas, and they're looking for violations. The agency, the FMCSA, when you look at it in comparison to the other agencies that are under the DOT's umbrella, the Federal Aviation Administration, for example, the FMCSA is tiny. It's really understaffed, and they just do not have the manpower to go out and review the records of the 525,000 carriers that they regulate throughout the country. So if they have not yet come out and reviewed your files, you don't have a safety rating. And like I said, that's the vast majority of the carriers in the country, that they just don't have a safety rating at all. So as I mentioned, the safety ratings are assigned following an on-site comprehensive compliance review. When they come in, and depending on the size of your operations, they're going to request a bunch of files. And what they're looking for are acute and critical violations. Those are the types of violations that impact your safety rating. And they're looking at these in 6 broad factor areas: general compliance, driver fitness, hours of service, vehicle maintenance, hazardous materials if you haul it, and your accident rate. Before I get to that next slide, let's talk about acute and critical violations. So an acute violation is a violation that is so severe that it requires immediate attention. These are all listed, I should say, in the safety regulations, the ones that are acute and critical. You can find them in Appendix B to Part 385 is where they're located. But essentially, if you think of an acute violation, a good example would be using a driver after he's tested positive for drugs or alcohol. That would be an acute violation. One instance of an acute violation has the potential of negatively impacting your safety rating. They're also looking for critical violations. A critical violation is one where they're looking for a pattern of non-compliance across all the files they're reviewing. And they use a 10% threshold to determine whether there's been a critical violation. For example, if they're looking at your driver logs, you know, they've requested a sample of driver logs for a 30-day period. They're looking at them all. You know, they're looking for violations of the 11-hour rule, the 14-hour rule, the 70-hour rule, and they're also looking for log falsifications. So a good example of a critical violation would be false logs. If, let's say, they're looking at 200 driver on-duty logs, if they find that 10% or more of those logs are falsified, that would be a critical violation, and that has the potential of impacting your safety rating. And again, this is all how it currently works. This is not the new rule. This is how it currently works. So once they finish the review in those 6 factor areas and they tally up all of the critical and acute violations that they discover, if they find no acute or critical violations in one of the factors, then you get a satisfactory rating in those factors. If they find one acute or one critical violation in any one of the factors, then you get a conditional rating in the individual factors. If they find 2 or more acute or critical violations in a particular factor, then you get an unsatisfactory rating in that factor. And then they use this chart to determine your overall safety rating. And so you can see on here that, you know, looking at all of those 6 factors, if you had 0 unsatisfactory factors and you had 2 or fewer conditional factors, then you get an overall satisfactory safety rating. And then it just goes down from there. So, you know, for example, if you had 1 unsatisfactory factor and more than 2 conditional factors, then you get an unsatisfactory rating. And so that's the chart they use to determine your overall proposed rating. Now, it's called a proposed rating for a reason. So after their review, they'll give you a report that has all of the critical and acute violations. It'll have a proposed safety rating of satisfactory, conditional, or unsatisfactory. As soon as you get that report, that starts a clock, a regulatory clock, where you have a certain time frame to do something to get that rating upgraded if you need it upgraded. Obviously, if you have a satisfactory rating, there's nothing to do. You have 2 options to get your safety rating upgraded. You can file a legal challenge if you believe that the auditors made some kind of a legal error in assessing the violation. That's called a 385-15 challenge. Or you can fix, if you don't challenge a violation, if you admit that violation, then you can correct the issue, and then you can petition the agency to upgrade your rating based on your corrections. You can say, look, I fixed it. Here's evidence that I fixed it. Upgrade my safety rating. That's called a 385-17 petition. Depending on whether you haul hazmat or not, dictates what time frame you're working with here. If you haul hazmat, you have 30 days from the date you get the report to get one of these on file before your rating becomes final. If you don't haul hazmat, then you have 45 days to do that. Importantly, even if you were to file one of these challenges or petitions, that doesn't stop the clock. So even if you get that filed in time, at the expiration of the 30 or 45 days, your safety rating is going to become final. So, you know, the idea is to get these filed as soon as possible so that the agency has time to review them and rule on them before your safety rating becomes final. Because if you have an unsatisfactory safety rating and that becomes final, you're going to be put out of business. The legal challenges, that it goes through an administrative review process. It's reviewed by the agency's chief safety officer in Washington, D.C. We file these quite a bit for our clients where, we're arguing legal issues for them. There's kind of a back and forth with the FMCSA Service Center that sent the auditors out to you. They get to brief the issue. We get to brief the issue. And then the chief safety officer decides whether you're right or wrong. And then you have some appeal options from there. You could appeal it up to federal court if you wanted to, if necessary. The 385.17 process is a little more tricky. As I mentioned, this requires you to make some corrections and then prove to the agency that you've made those corrections. Now, I assume all of you are pretty lucky in the sense that you are situated probably in the agency's Midwestern Service Center jurisdiction. So they have jurisdiction on the East Coast, they have one on the West Coast, they have Midwestern, and they have Southern Service Centers. So I assume a lot of you are in the Midwestern Service Center. You may be in the Southern Service Center, I don't know. But the Midwestern Service Center is pretty easy to work with in terms of proving to them that you've made corrections, and they're willing to work with you on getting your rating upgraded based on that documentation. If you're unfortunate enough to be located in the Western Service Center, it's not that easy. They're sticklers. They're not easy to work with. And it's very rare to get a safety rating upgraded on the West Coast before that safety rating becomes final. So obviously these safety ratings have they're a huge asset for your company. You have to protect them at all costs because they have the potential of completely shutting you down. Okay, so that's the current safety rating process. It's complex enough in its own right. Now the agency is, like I said, seeking to completely overhaul it and make it even more complex. So, the big change is they're getting rid of the 3-tier rating system altogether. This is their proposal. Again, this is a proposed rule. This is not a final rule. They're going to get rid of the 3-tier rating system in favor of a single safety rating of unfit. You're either unfit or you have no safety rating at all. That's going to be the only safety rating, is unfit. The safety ratings will be assigned one of three ways. Either through agency investigations, as they are currently, where they come in and look at your records, or through on-road safety data gathered through roadside inspections. And all of that data, as you know, currently is funneled into the agency's CSA or SMS, which is their safety measurement system. That's where you can get online and see what your scores are. They're proposing to use that as a basis to give you a safety rating, or some combination of the two, a combination of an agency investigation and your on-road safety performance. Why are they changing the way that they do safety ratings? Well, their justification is that, and we kind of already hit on this, currently the agency can only investigate approximately 17,000 carriers per year. That's all the manpower they have out of the 525,000 that they regulate. And so, and 1,000 of those currently result in a proposed unsatisfactory rating. They're estimating that by now including SMS data, roadside performance data as a basis to give you a safety rating, that they will be able to expand their reach, and that an additional 2,000 carriers per year will get a proposed unfit rating. So it's going from 1,000 per year to 3,000 per year that are going to get the equivalent of an unsatisfactory rating. So let's get into the weeds on how they're going to give you a safety rating under the new process. Essentially what they're going to be doing is looking at your performance on a monthly basis in 7 basics. So remember, under the current system, they're looking at 6-factor areas. Under the proposed rule, they're going to be looking at 7 areas, and these are the 7 areas that currently make up the CSA SMS system, the 7 basics as they're called. And they're going to be looking at all 7 basics And they're going to say that if you fail 2 or more of those basics in a given month, then you get a proposed unfit rating. So that's what they're looking at. 2 or more failed basics in a month gives you a proposed unfit rating. So how do you fail a basic? Well, it depends whether they're doing it with roadside data or through an agency investigation. Let's talk about the roadside data first. And like I mentioned, this gets really complex. So, I'm going to have time for questions afterwards, certainly. So, feel free to ask any questions if I'm not explaining this well. So, in terms of roadside basic failures, it's important to first point out that when they're looking at roadside data through the CSA program, they're only evaluating you on 5 of the 7 basics. In other words, you can only fail 5 of the 7 basics through roadside data. The other 2, which we'll talk about, you can only fail through an agency investigation. The 5 that they're looking at based on your roadside data are unsafe driving, hours of service, driver fitness, vehicle maintenance, and hazardous materials if you haul it. Over the years, there have been several problems with the agency's CSA program, and I'm sure you're probably keen to those problems because it affects your businesses. And these problems have been pointed out to the agency time and time again. One of the problems is data sufficiency. The inherent unfairness of comparing small carriers to large carriers, carriers that don't have much inspection activity to carriers that get hundreds of inspections per day. That creates a problem with the data that the agency has tried to address. And the way that they're going to address it in the new rule is twofold. First of all, in order to fail a basic through roadside data, you have to have a minimum of 11 inspections with violations in that basic in a 24-month period to even be eligible to fail a basic. And the reason they're doing this is they don't want you to have, let's say you have, you only have 1 inspection in a 24-month period that has an hours of service violation. Well, they don't want that 1 inspection to dictate your safety rating. So they're saying to make sure that we're kind of looking at averages here, you have to first have 11 inspections with violations to even be eligible to fail a basic. So they're trying to throw you a bone here a little bit. So if you don't have that many inspections, just by the nature of your operations in the 24-month period, then you won't be eligible to fail that basic on roadside data. They would have to come in and do an agency investigation. The other way that they're trying to address this issue with large carriers versus small carriers is that, and this is kind of how it's currently set up, the SMS system, is that you are going to be compared to carriers of similar sizes. You're not going to be compared, if you're a small carrier, you're not going to be compared with the Walmarts and the Landstars and the Schneiders of the world. You're going to be compared with carriers that have similar number of inspections in a 24-month period. How do you fail a basic with roadside data? Well, here's how you're going to fail a basic. The agency is proposing what they call an absolute failure standard for the 5 basics that they're looking at. Carriers whose scores exceed that absolute failure threshold in a given month will fail that basic that month. So what's an absolute failure standard? Well, you may be inclined to think, well, that's my threshold score, right? Nope, it's not your threshold score. It's not your intervention threshold score. And we'll talk about the reason it's not in a minute. But this may be a screen that you're familiar with if you ever log into your SMS account to look at your scores. It's essentially broken up into 2 parts. There's the left side and the right side. So this particular, this is the vehicle maintenance basic that we're looking at here for this particular carrier. If you look on the left side, this carrier has exceeded the intervention threshold. The intervention threshold for vehicle maintenance is 80% for this carrier. They're at 84%. Now let's talk about an intervention threshold. What is it? As you probably know, that if you exceed the intervention threshold, in any of the basics, you're going to get a flag. You're going to get that warning triangle in that basic. And that essentially means that you're probably more likely to get targeted by the agency for either more frequent roadside inspections, or they may come in and do a compliance review. That's how it currently works. You're concerned about exceeding these thresholds because it will put that warning triangle up, and then you may be targeted. That's an intervention threshold. Essentially what it's saying is that you are performing worse than a certain percentage of carriers that are of a similar size to you. This particular carrier is performing worse on vehicle maintenance than 84% of all carriers of a similar size. That's what it means. On the other side is your absolute score in the vehicle maintenance category. So if you're looking at this side, this is not comparing you to other carriers. This is just your personal score. This is, in each violation that you get in a particular basic is given a weight based on how long ago it happened, how severe that is, and that score then, if you have multiple violations, they start to add up, and that raises your absolute score. So these are your absolute scores. So what the agency is proposing is that to fail a basic with roadside data, they're not going to look at this side. They're going to look at this side. And if you can imagine a red line being drawn across the top there, just a straight line, if your absolute scores go above that straight line, that red line in a given month, that would mean that you failed that basic. This is another question that I get a lot of, and I understand it because this is hard to understand. I don't understand the difference between a threshold and an absolute failure standard. Why the difference? What is the difference? And the best way I've come up with to explain this is by analogy. And it's so complex that even my analogy is complex. So I've had to kind of pare it down over the last couple months. So here it is. I have a son at home who's almost 2 years old. Like other kids his age, he goes to the doctor occasionally every few months, gets a checkup. When he comes home with like a report card that lists his height, his weight, and then it says what percentile he's in for those two areas. And so, if you can't tell from looking at me, my son is always pretty low on the height scale, and so he's usually comes in at like the 30th, 35th percentile for his height. And so if you can imagine that is similar to your intervention threshold. The percentile, his percentile height is similar to your intervention threshold. It's a comparison between my son and other kids his age, as are your intervention thresholds is a comparison between your performance in that particular basic and other carriers of a similar size. Versus, also on that sheet that my son gets is his actual height. If he's, I don't even know what he is. If he's 2 foot, 3 foot something, that's his actual height. That it doesn't matter what other kids his age height are. That's his actual height. So that would be like your actual. That would be your actual measure. So that's the distinction. So where are they going to draw that line? What's the line going to be that's going to dictate whether you fail that particular basic? We don't know yet. The agency is proposing to use a cutoff that will essentially equate to the 96th to the 99th percentile in each basic. And here's the problem. One of the biggest problems with the SMS system is that it relies so much on relative performance, your relative performance to other carriers in your same peer group. And what that means as a practical matter for you is that, remember that I said violations affect your score and they have different weights based on how old they are. So after 24 months, a violation falls off your scores completely and doesn't impact your scores. So, but if it just happened yesterday, it's going to impact your scores more than if it's older than that. So imagine this example. if you have a score that's teetering near the intervention threshold, teetering on the intervention threshold in a particular basic on a given month. Now, let's say a bunch of carriers in your same peer group are right there with you. They're right there on the tipping point. But let's say that they have a bunch of old violations that are making up their score that are getting ready to fall off that next month. But let's say you don't. You have all pretty recent violations that are putting you at that same place. Well, that next month, when all of their violations in that basic fall off, their scores are going to go down, and yours is going to go up, even though you had no more violations that month. It's just because that's the nature of it. You're compared against your peers. And so even though you had no more violations in that basic that month, your score is going to go up, theirs is going to go down, you're going to be above threshold, and you're going to be targeted for enforcement action. That's one of the biggest problems with the SMS system. You probably know that recently, at the end of last year, the U.S. Congress finally did something about this and told the agency, yeah, we think there's a problem with the CSA program. You need to take down from public view all the carriers' percentile scores. Remember, those used to be public for anybody to see. Congress directed them to take those down, so they're down now. Nobody can see your scores except you and law enforcement. And they said to the agency, you need to commission a third party to look at your CSA program, figure out what the problems are, if any, and there are problems. Have them prepare a report. You need to correct those issues, and then we, Congress, need to look at it and make sure that you've corrected the issues before we can continue to rely on this program, this system. So that happened late last year. Your scores have been taken down from public view all that time. But in the midst of all that is when the agency proposed this new rule, which is going to rely on your scores to dictate your safety rating. And so, you know, I mentioned that the comment period is closed on this. There were hundreds and hundreds of comments submitted, and a lot of them were dealing with this issue, that it's not fair for the agency to be relying on a system that so many have shown to be flawed, to use that system to then dictate your safety rating, which, as we have talked about, is so important to your businesses. So keep in mind that there's been a lot of pushback on this rule, particularly the use of roadside data to impact your safety rating. So where it stands now, as I mentioned, is that it's not a final rule yet. The comment period's closed, so the agency's looking at all of the comments. We don't know where they're going to go from here. They may make some revisions. They could go ahead and publish it. We won't know until we, you know, see what the agency does. So that's where it stands. That was kind of an aside because we have yet to talk about the other half of how you can fail a basic, and that is similar to the current system, which is through agency investigations. There are a few changes that I think are notable to talk about here. So the other way you fail a basic besides roadside are agency investigations. The difference is, you know, currently they have to actually come to your facility and review your records. Under the proposed rule, they can do these on-site or off-site. They could tell you as a carrier, send me these documents, and they're going to look at hours of service logs, for example, and you could fail a basic that way if they find violations. And now what they're looking for, again, are acute and critical violations when they're doing these investigations. But recall, under the current system, it takes a minimum of 2 acute or critical violations in any factor to get an unsatisfactory rating in that factor. It takes a minimum of 2 currently. Under the proposed rule, it's only going to take 1. If you get an acute or critical violation in any one of the 7 basics, you're going to fail that basic that month. And remember, if you fail 2 basics in a month, that's a proposed unfit rating. So what do you do when you get a proposed unfit rating? Well, there are similar options in place for you to address that. You can still file a 385.15 administrative review. They've shortened the time frame within which you have to do that. Now you have to file it within 15 days. It's in practice, it's not going to make that much of a difference in my mind because, like I said, currently you want to do that as quick as possible so that they can rule on it within 30 or 45 days. Now they're saying you have to have it on file in 15 days so that they can look through it and rule on it. The other option, again, is to file the 385-17 upgrade request, which is where you've made corrections and you're asking the agency to upgrade that rating based on those corrections. Now, this has a pretty significant change to it. So currently, you can just make the corrections, give the agency evidence that you've made the corrections, and then get it upgraded. That's how it currently works. Under the new proposed rule, you're going to have to do something more. Not only are you going to have to make the corrections and prove that you've made the corrections, the agency is going to force you to enter into a contract with them. And it's a contract that's going to say, you as a carrier are going to agree to our terms, and here are the terms, over the course of probably a 2-year period. And if you breach any of those terms, then your unfit rating is going to come back. And no doubt about it, you're going to be entering these contracts against your will, and you're not going to have any leverage really to negotiate the terms of these contracts. We know from what the rule said that, for example, one of the terms is going to be you will agree to keep all of your basic scores under the intervention thresholds that entire 2-year period. And you know how tough that can be and how tough that is. That's going to be one of the terms of these compliance agreements. And if you kind of look at this, that can kind of be seen as a back way of using the intervention thresholds to set your safety rating. Remember, Congress told them, you can't use those intervention thresholds to set a carrier safety rating. We don't think they're reliable enough. So that's why they did the absolute failure standards. This is kind of a back way of getting to that same result where once they've got you with an unfit rating, they're going to force you to keep your scores under the intervention thresholds relative to everybody else that's similar size to you in order to not have that unfit rating take effect. So that's a pretty significant change. It's one that garnered a lot of comments during the comment period. The last item there is unconsidered inspection data. So this is a new part or a new review process that they're proposing adding. It'll be in 385-16. And this is just essentially if you fail a basic because of some roadside violations, and you think that the agency or the officer who assessed you those violations didn't consider some kind of pertinent information when he assessed those violations, you can submit that information through this process and hopefully get that overturned. FAST Act implications. So the FAST Act is the act of Congress that I talked about where they said take down from public view the carrier's percentile scores. Again, based on the comments that we've seen, we think that there are some implications here when the agency issued this rule in light of Congress's directives in their FAST Act where they said you need to commission this report, study it, and fix the issues. We think there's some serious problems here with the agencies pushing forward with this rulemaking despite Congress saying there's problems with that program. And we've already seen some members of Congress speak out against this rule and say, hey, FMCSA, what are you doing? We told you specifically that you need to evaluate this program. It hasn't really gone anywhere yet. It hasn't really gotten any legs yet, but we'll see what happens. Comment period's closed, and that's all I have. So, at this point, I usually ask if anybody has questions, and after that whole analysis, usually people don't even know what questions to ask because it's just so confusing. So I'll open it up to questions. Happy to answer any that you may have. My prophecy proved true. Nobody knows what to ask. I'm certainly going to be around for a while, so feel free to come up and talk to me if you have some individual questions.
So what you're saying is the absolute score per basic is yet to be determined?
They're not determined yet. They are going to be set by rule eventually, and they're only going to be able to be changed by a formal rule that carries a comment period of its own, et cetera. So what they were doing with the proposed rule was requesting comments on what carriers think the absolute failure standard should be per basic. Like I said, their proposal is to use a standard that it essentially equates to the 96th to the 99th percentile in each basic. And what's that saying? It's saying that they're hoping to target the worst 4% of carriers in the country in each basic as the ones that will fail those basics. Any other questions? That's it for me. Thank you.
Thank you.